Hello, this is Jeremy Finger with Riverbend Wealth Management. I am with attorney Meghan Barnes out of Pawleys Island. She helps people make sure their estate documents are in order. And welcome, Meghan.
Thank you very much. I'm glad to be here.
Perfect, perfect. Well, tell me a little bit about yourself, what types of clients that you take care of, and what you provide them.
Sure. I've been in the area for about 5 years, practicing solely in the areas of estate planning and probate work. So I'm very focused in that corner of the law.
Mhm.
I serve all types of clients. Certainly everybody needs an estate plan. And when I say estate plan, some people get confused as to what that is. We are talking about healthcare powers of attorney, general powers of attorney, a living will if you choose to sign that, which are kind of your pre-death documents that we plan for incapacity. And then we talk about your post-death documents. So we look to documents like a will or a trust or some combination thereof. And so that's what the majority of my practice is estate planning. And I help people from young adults that are in college all the way up to retirees. Certainly young parents that have young children are definitely in need of estate plans as much as everyone else.
Okay, well, that makes sense. Could you maybe just for what's like the definition? Like when would someone would need a why would someone need a healthcare power of attorney and why would someone need a living will? Can kind of just for the kind of give us a little bit of a basic information there so that we can.
So we sign healthcare powers of attorney so that if you were ever unable to make your own healthcare decision, that somebody has the legal authority to make those decisions for you. So if you are a parent of a child that's going to college, they turn 18 years old, you no longer have the ability to make a healthcare decision for them. So if they are in an accident, it's a good idea for that child to have a healthcare power of attorney appointing their parents as their decision makers. A lot of times hospitals won't even talk to other individuals due to HIPAA regulations and HIPAA laws. Without a power of attorney in place. So that's your healthcare document.
Okay.
Also, same goes for a general power of attorney or a financial power of attorney. So nobody has the legal authority to pay your bills or manage your finances on your behalf unless you sign that document.
Okay.
If incapacitated and you're unable to sign the document, your loved ones typically go to the probate court and ask to be appointed as your guardian and conservator. So guardian is someone that makes healthcare decisions for you, and a conservator is someone that makes financial decisions for you. And that is a very burdensome and expensive process. So if it can be avoided by signing a power of attorney, then that's certainly the way to go.
Okay. So it's much better to do it on the front end versus during the time of duress.
Absolutely. You do not want to file an emergency guardianship action.
Yeah. Yeah, that makes sense. And I mean, husband and wives need to do the same, make sure they have those same things in place?
So a husband and wife, they do not have the legal authority to speak on behalf of their spouse. There are emergency situations in which a hospital or physician will talk to a spouse. And sometimes in smaller towns, you can get away with it, but certainly the bigger hospitals or a bigger town, you can end up in a lot of trouble if you do not have a power of attorney in place.
Okay. All right. Perfect. Makes sense. So it's better to do like the ounce of prevention versus a pound of cure, right? Yeah. Perfect. What about like living will versus regular will and the differences in that?
So in South Carolina, we call a living will a declaration for a desire for a natural death. It goes hand in hand with your healthcare power of attorney, and it is a declaration to your physician about what your end of life decisions would be. So, do you want to receive artificial nutrition and hydration in two circumstances? The first is that you are terminally ill and you're going to die within a reasonably short period of time. And the second is that you're in a permanent state of unconsciousness. So what are your wishes? A lot of times, people want their agent under their healthcare power of attorney, like their spouse or their children, to make that decision for them, in which case we would not sign a living will. So I usually go through those kind of options with people at the time we sign the documents to decide whether that's a document that you want to move forward in signing.
Okay, all right, that makes sense. So you make sure that they got all their stuff set up. You go through all the different options and see which one's best for them. All right. Well, what about if like someone has moved to the area and they got their stuff set up in New York or New Jersey or Ohio, and they got it set up 5 years ago, and they moved to the Myrtle Beach or Grand Strand area or Columbia or whatever. What do they need to be thinking about?
Most states have very specific laws in regards to their healthcare powers of attorney and their financial powers of attorney. So it's very important for people that move to South Carolina to revisit those powers of attorney, even if they were recently done in another state. South Carolina has specific healthcare powers of attorney. As in addition to the living will, those are state specific forms. So if your intent is to remain in South Carolina, it's best to go ahead and sign a South Carolina power of attorney.
Okay,
The other,
is that cumbersome? Like if they've spent all this time and effort to do these legal documents in New York or New Jersey or Ohio, and I'm just using that for example because it seems like everybody who's moved here is from there. Um, is it cumbersome to make these updates or to
it
do?
is not. A power of attorney is a super simple document. It is not an expensive form to sign. They don't take long to draft. They don't take long to review with clients. So it is um, a very simple process to update those forms. A little bit more work and time goes into your wills and trust. But certainly the powers of attorney, those should be updated immediately. Especially the financial power of attorney. Different states have different laws, and our laws were updated just a few years ago. The whole power of attorney statute was revised. So
Really?
even if you're from South Carolina and you have a power of attorney that was done 5 or 10 years ago, you should probably have it looked at because the laws have changed.
Okay. Well, I mean, what kind of changes have they made? I mean, is there anything like if someone didn't do anything, just says, I might Google legal Zoom or whatever. What are some of the things that someone who decides not to do anything? What are some of the dangers that they putting themselves in, them and their families?
The new code, the new statute says that there are certain powers that have to be enumerated or spelled out in the power of attorney for your agent to be able to do, such as the power to sell real estate or the power to make gifts. If that is not specifically spelled out in the document, your agent does not have the power to do that. A lot of times I see older documents that say, my agent has the power to do anything with my finances that I can do. And it's just a short 2-page form, power of attorney that somebody pulled off the internet, or somebody went to an attorney that didn't have experience in estate planning and prepared for them. And you're no longer able to use just those blanket powers of attorney. Every power has to be spelled out. So the POAs now are a lot longer than what they used to be.
Okay. So let me give you like a scenario, if you don't mind. I don't mean to put you on the spot here, but like let's just say a husband and wife, and they don't have their documents set up, and one spouse becomes incapacitated and they need to take a required minimum distribution or something like that. The other spouse would need to have those powers of attorney in place to make sure that they're not penalized for not taking things out and those types of things.
Absolutely. Absolutely. And I'm sure you're aware no spouse, you're not allowed to take information from a spouse if they're not on the account without a power of attorney.
100% the case, and that's what we try to make sure that they look, if something were to happen, is everybody else going to be taken care of and vice versa? So, and a lot of times that involves, someone with your knowledge and skill to be able to make sure those documents are in order. So,
And what I see also a lot of times with powers of attorney from other states, here, in order for a bank to accept a power of attorney, it usually has to be recorded with the Register of Deeds. So it's put on the public record. What I see a lot of times is other states don't do that. So they're not recording their powers of attorney. But in order for South Carolina to record an out-of-state power of attorney, it has to be recorded in that state first. So a lot of times, especially in states like New York, where the recording fees are so high, it's less expensive just to redo your power of attorney here than for us to mail it to New York, have it recorded there, shipped back, and then recorded, here in Georgetown, Horry County.
Okay, so let's just say someone drew up a document and I love my wife and here's what I want to do, and she did the same thing. Then they sign it because that's not being recorded, right? That there's some things that may not transpire the way that they want. Is that kind of what you're saying?
For the power of attorney, the financial power of attorney needs to be recorded on the public record.
Okay, all right, perfect. Anything else, like, that people who move to the area, what they may need to be thinking about, or if new parents and second marriages, and there's a lot going on with someone's life.
There is. Certainly we've been kind of focusing on powers of attorney. Wills and your trust are another thing to consider. The tax laws that are differing, in different states. Like, for instance, New York has a state tax. And so anything over about $5.5 million is taxed at the state level when
Okay.
you pass away. South
Okay.
Carolina does not have a state tax. So if you have a trust that was prepared in New York, a tax planning trust, okay, that takes
Okay.
into consideration the state tax, and you move here, that's something to certainly look at, and get an attorney experienced in tax law and trust law to review.
Because the language they may have in that trust, it may be specific for that state, and it may cause a bit more confusion for that estate if they're in the state of South Carolina where there is no estate tax. Is that kind of what you're saying?
That's right.
All right, perfect. Okay. All right. Anything else top of mind? Like, for people who move into the area, or new families, or second marriages?
Sure. Second marriages, certainly, need to be looked at with a close eye. We a lot of times use trust for second marriages to ensure that if you have children from a prior relationship, that your children are taken care of in the event that your surviving spouse remarries, or has a falling out with your children after your passing. You are the common denominator between your children and your spouse's relationship. And when you are gone, a lot of times that relationship deteriorates. So a lot of times we use trust, to
Right.
help eliminate that conflict. And they do a good job. But certainly second marriages, typically you want more than just a simple "I love you" will that says everything goes to my spouse if living.
Right, right. It can be a bit more complex in that, you have, let's say, the two spouses, and one spouse passes away, and then you have assets to take care of the surviving spouse. But when this surviving spouse passes away, then the assets go to the children of the
That's
first spouse. That's typically how I see it.
That's right. It's right. You want to make sure that your children receive your assets, after your spouse's passing.
Right. Can you also, within the area of trust, put like controls or strings on the money too, where, so like if Bobby Sue may not be financially well up on things, maybe he has to have certain hurdles to do to be able to get the money and things like that. Can you speak to that a little bit?
Absolutely. So you can put all kinds of controls. We can completely customize your trust to make sure that your spouse is provided for, and that their general standard of living is maintained. So if your spouse is used to driving a Honda Accord, and that's what they're comfortable with, and that's what you've always driven. We don't want you to pass away and then have your spouse go out and buy a Ferrari.
Right,
So
right.
to kind of maintain that general standard of living, to ensure that they're taken care of, um, but that may not be blowing through your assets. And there's a lot of ways to control that, whether we have terms in the trust or we create, um, or appoint a third-party trustee, whether that's a CPA or a financial advisor or another bank, to kind of oversee that trust is run the way it's supposed to run.
Sure, and you can do the same thing for children too, have strings on the, yeah, and that's the main thing, age 25, age 30, age 35, and those types of things as well.
We don't want an 18-year-old to inherit, your entire estate.
Yeah, right. Well, one thing's for sure is like when children inherit a ton of money, they become a lot cuter for the rest of the family members. So you really want to make sure that you have things set up in a way that is providing for the benefit of the child in the way that they're accustomed to.
That they have
Yeah,
money for college or money for down payment for a house, money if their car breaks down or they have health care, um, that they don't have full access to the money.
sure. Like there's a HIMSS clause, right? Health, education, maintenance, and support. Right. Perfect. Well, Megan, if someone wanted to get in touch with you, how would they go about doing that?
My office number is 843-314-8044. I also have a website that's Law Office of Meghan Barnes, and my name is MEGHANBARNES. You can also email me. My email address is megan@lawofficeofmeganbarnes.com. We are here every day, Monday through Friday. We do close the office a little early on Friday afternoon to try to enjoy this weather here. And
Perfect.
we are here and able to set up a phone conference, Zoom conference, in person. My office is in Pawleys Island, and I have a gorgeous view of the beach here. But if you need for me to travel, I do travel to people's houses. I even go to nursing homes or assisted living facilities if that's
Okay.
have a great paralegal who goes with me to serve as a witness if we need to do that.
Perfect. That's a very big help. And you're also able to, do Zoom and things like that. And if you need to get a wet signature on things, there's usually a bank or a CPA firm or something like that can help to stamp those things.
Absolutely. I have clients in the Midlands and upstate, and we work through, all that together.
Perfect. Okay. Well, if you got questions about anything at all, in regards to estate planning or estate documents, the pros and cons, feel free to contact Meghan Barnes. And thank you, Megan, for your advice here. It's been a pleasure chatting with you, and hopefully people find that beneficial.
Absolutely. Thank you for having me.